So thanks to you and to everyone else that organized this and put it together. I think this concept and the goals behind it are really encouraging, and it's a great outbranch of the movement going, in different directions and seeing how far we can spread what we're already doing. So thank you all to that. I'm grateful to have been invited to talk. Hopefully it'll be worthwhile. I think based on the outline, I'm talking about a recap of what happened yesterday. So in sum, a whole bunch of nothing happened. But to frame this, I'll tell you what was anticipated to happen at yesterday's hearing. It was an accounting hearing. So back in, I believe, November, December, or gosh, it could have been further back than that, the accounting report for the prior year was filed. And Ingham, who is Britney Spears' court-appointed attorney, he filed 5 objections to the accounting report, which is separate from his objections to the motion to seal. These were specific objections to what was in the report and the transactions that the conservatorship was showing to have occurred. Unfortunately, we got to the hearing and nothing happened. I was expecting one of the 5 objections to be resolved at the hearing, because it's the only objection in which Ingham specifically asked the court to disallow a transaction. With the other 4 objections, he was asking the court to decide whether or not the conservatorship and Jamie Spears' attorneys needed to provide additional information so he could flush out whether or not the transactions were appropriate. None of that was addressed. Instead, what happened was Vivian Thurine got up and told the judge that her and Sam Ingham had been exchanging meet and confer correspondence. So meet and confer is whenever there's a discovery dispute, the attorneys have an obligation to meet and confer, which essentially means get together and try to work out and resolve their discovery disputes among themselves without the court having to intervene and make a ruling. And the courts highly encourage this. In my jurisdiction, it's required. You can't even bring a motion to compel or ask the court to give or ask the court to command a party to give you evidence until you can show that in good faith you met and conferred and try to resolve the disputes among yourself. So that's what Vivian Thurine told Judge Penny was going on, and that the meet and confer correspondence were ongoing. Therefore, there was nothing to discuss at yesterday's hearing. I find it unfortunate. I really think Ingham needs to step up and say, we gave it a shot. We did some meet and confer, but my client's paying for all the attorneys on both sides. And the more time we spend talking about our discovery disputes and coming to court and showing up, she's the only one paying any money for it. Lynn's paying money as well. Lynn's attorneys aren't covered by the conservatorship. But I think Britney's taking the hardest hit financially every time, the attorneys show up for a hearing that goes nowhere. And for me, it was really frustrating because I deal with this a lot, and I don't like to go to court if I don't have to, especially pre-pandemic. I would have to drive down to court, wait around in the galley for like an hour, and then go talk to the judge for 5 minutes. It takes a lot of time out of my day. So I always, in these situations, if I'm on the same page as opposing counsel, I'll shoot them an email, maybe a week before, give them a phone call and say, hey, there's really no reason for either of us to waste our time going down to court just to tell the judge we're going to, pass it along until the next court date. Let's just put it in writing, submit an agreed order, and pass the hearing. There's no reason to go. I think that's what should have happened. Unfortunately, it did not. The other interesting thing that occurred at the hearing yesterday was Ingham said that a petition will be filed sometime before the next upcoming hearing, which is on April 27th, to make Jody Montgomery the permanent conservator of the person. There has been a lot of disagreement among everyone about whether or not Ingham is doing his job by not having filed a motion to terminate the conservatorship yet. I'll put the conservatorship of the estate aside. When it comes to the conservatorship of the person of Britney Spears, I see no reason whatsoever that a motion to terminate has not been filed yet. I mean, there's no evidence that's in the public record that shows that she needs it. Actually, the evidence that's in the public record speaks to the opposite, that she doesn't need this conservatorship of her person. I think that the time's come, that should be filed, and that can be resolved. That's not what happened. The opposite happened, obviously. But going back to the conservatorship of the state, I do see a strategic reason for keeping that open. I don't know if it's Ingham's reasonings, but from what I can see, it would make sense to keep that open now, because at this point, all the entities and individuals who were involved in Britney's finances and her entertainment ventures over the years, the court has the authority and jurisdiction over them to compel them to produce documents and to take certain actions. So when Ingham or Britney or any attorneys that she hires at some point down the road want to, pursue all those avenues and find where the money is and go through the books, keeping the conservatorship of the estate open at this time is more beneficial because the court has the power right now. If it was closed out and everything was dissolved and Britney wanted to go back and reclaim the money that appears to be missing, that would require a whole new civil lawsuit to be filed, which just getting that kicked off in the initial preliminary investigation would be a lot of time and a lot of money. So that's basically my summary of what happened and my thoughts on what happened yesterday.
I just want this one, Sam, this one, just to kind of get it out there, who exactly can file for termination, and does it have to go through Samuel Ingham?
So under the California probate statutory scheme, anyone that has a close relationship or is a family member with the conservatee, in this case, Britney Spears, can petition the court to terminate the conservatorship, and they can do so outside of Britney's court-appointed attorney. So no, it does not have to go through Sam Ingham.
Okay. Let me see. Along those lines also, if Jamie were removed, would there theoretically be anyone to object to the termination of the conservatorship? So I guess I'll rephrase that by asking, who, if a petition was filed to terminate, who would be able to, if anyone, to object to that petition?
That's actually a very good question. So Jody Montgomery would be in position to object to it. Bessemer Trust would also be in the position to object to it as well. But I mean, the important point is that it's not necessarily the fact that there needs to be someone to object to it. And this is a really big problem that I see. I think this is really crazy. It's not, doesn't sound like legal speak, but just crazy that the burden is on the conservatee to say, I don't need this. That's insane. If someone's rights are being taken away, it shouldn't be their burden to say, I need my rights back. It should be the state's burden to say, there's a reason that this person shouldn't have the full set of rights as every other individual in this country has. That burden is on the conservatee to say, I need these rights. And that's very problematic in my opinion.
Are conservators required to prove in any way why and how they are fit to act as conservators or guardians?
Yes, they are actually. And that is why in 2008, Jamie Spears, the conservator of Britney Spears, had to file a declaration informing the court that he is a recovering alcoholic, which no shame there, good for him. But he had to disclose that because it's something that's relevant to his qualifications. He had to disclose other information as well. But absolutely, there are qualifications, but they aren't quite strenuous.
I know there's been some kind of thing circulating around. I forgot where I read it, but I know some have said that Jody Montgomery was on as a in some sort of care role prior to being assigned as conservator. If that is the case or was the case, well, I guess first of all, is that the case? And then secondly, if she was already on board, would there hmm, would there be a conflict there if she were brought on board by Jamie, who was no longer the conservator of the person?
Sure. First of all, from my understanding, she was involved before she became conservator of the person. I believe her role was the title was care manager. You can fact check that, Google it. But I think she was part of Britney's treatment team, whatever that is. As to whether or not there's a conflict, no, not in the public record or in the court record, because it's important to point out that the court was not made aware of what I believe to be the real reason for Mr. Spears stepping down from being conservator of the person. The court was told that Mr. Spears was forced to step down because of his health issues. I think there is information out there in the public realm that highly suggests that that was not the actual reason for him stepping down. So the court can only operate off of the information it's provided. And as far as the court knows, Mr. Spears reluctantly stepped down because he was dealing with illness at the time. And the court has, no one has given anything to the court to make it doubt that.
And this is a combination of someone's question, also a question that I have myself. Would the judge theoretically be able to subpoena Britney to appear in court?
Anytime. Absolutely.